Sometimes I'll. So.
Okay, so we.
Yeah, I mean, that seems like the better name.
All right.
Take your, you may want to take the paper copies of the slides because they are, as you know, the text is small. Okay, I think we'll get started. I'm Bilal Sayed. I'm the Director of the Office of Policy Planning at the FTC. I'm not going to take much time up here at all. We'll get right into the program. This is our second day at Georgetown. It's the 8th day of our hearing sessions on competition and consumer protection in the 21st century. I just want to make a few points. This whole event is being webcast, recorded and transcribed, so your participation here or presence here may be reflected or may be captured on the FTC's website for forever, I hope. There's a correction to the, I think, the network to access online. It is GuestNet, GUESTNET, should pop up, and there's no password. The upcoming slides are dense, so if you're sitting in the back and you don't access the slides either in hard copy or on your device, you will not see them. My eyes worked about as far back as 5 rows. Yours may be better or worse. And then, okay, so let's get started. So Commissioner Phillips is going to start us off with opening remarks. I'm not going to say much about him except that he's a commissioner, and prior to being confirmed, he was chief counsel for Senator Cornyn.
Thanks, Bilal. And thanks everybody for being here today. It's really an honor to be here in front of you, and in particular to have the chance to kick off a day with so much to discuss. We have 2 big topics that we're going to talk about today. As some of you know, this hearing was originally scheduled to happen earlier, but had to be rescheduled because of the hurricane. And so in the meantime, we've already had a chance to explore some issues that actually can inform some of what we're going to talk about today. So today we take on the very modest task of looking both at vertical mergers and the consumer welfare standard. Both have made headlines of late, which is not always true in antitrust world. The Department of Justice's ongoing litigation regarding the mergers of AT&T, or the merger of AT&T and Time Warner, has drawn a great bit of attention, in particular to vertical merger law and the economic theories surrounding it. And we've heard a great deal almost every week on op-ed pages, on television, and so forth regarding the consumer welfare standard. So this is an important time, it's an appropriate time for the FTC to be convening a hearing on these 2 topics. My remarks today will be brief. I just sort of want to set the table and talk a little bit about what I hope to hear from some of the discussion. So again, our first topic is vertical mergers. For those who are not aware, which probably aren't the people here today, but because these are supposed to be an edifying experience for the nation at large, vertical mergers combine 2 firms at different points in the supply chain. And they are frequently juxtaposed with another kind of merger, horizontal mergers, which combine direct competitors. In 1978, in the antitrust paradox, building on work of his that went back decades, Robert Bork expressed skepticism of the likelihood of harm from foreclosure, which we'll talk about in a moment, and confidence in efficiencies like eliminating double marginalization that would flow from vertical mergers. Vertical mergers also can mitigate free riding, and they can align incentives between the two firms and reduce the friction that they have in negotiating contracts with each other to achieve those efficiencies. And consistent with these theories, a lot of studies about which we'll hear today have shown that vertical mergers are generally pro-competitive or at the very least competitively neutral. Accordingly, the Commission has, as a general matter, typically taken a more skeptical view of horizontal mergers than they have of vertical mergers. But that is not to say that vertical mergers never raise competitive concerns. We'll hear today from, among others, Steve Salop, whose work in the 1980s concerning the theory of harm from raising rivals' costs finds its expression in enforcement that we and the Department of Justice do every day. In the vertical merger context, this theory posits that an integrated firm with sufficient market power may be able to exploit its preferred or exclusive access to critical inputs or customers and thereby raise its rivals' costs of competing for those inputs or customers and could potentially harm the competitive process. Vertical mergers also raise the prospect of other anti-competitive harms, such as increasing the likelihood of collusion. While U.S. antitrust authorities routinely review vertical mergers and sometimes bring enforcement, neither the Commission nor the Department of Justice Antitrust Division have updated formal guidance since 1984, which is a long time ago. The Antitrust Modernization Commission and the ABA repeatedly have called for updating vertical merger guidelines. Critics note that the agencies have updated horizontal merger guidelines as recently as 2010, and that those guidelines have gained wide purchase in the bar and even by courts. And so today, for lawyers in particular and firms considering transactions, they offer meaningful guidance, as well as a tool for developing clear and consistent case law. These same critics note that the 1984 non-horizontal guidelines, which by the way are a DOJ product, not an FTC product, are outdated and do not reflect current agency practice. Earlier this week, Assistant Attorney General Makin Delrahim stated the guidelines are not used and do not reflect new evidence or case law. So today, part of what I hope to hear is what we have learned about vertical mergers since the early 1980s. How have the theory and the practice changed? What are the areas of vertical merger law that are unclear to businesses or courts from which the public, including those businesses and courts, would benefit from guidance from us at the agencies? Critically, do we have empirical support for the competitive benefits or the costs that are alleged to flow from vertical mergers? And would that empirical support itself presumptions in the law, either for or against? How reliable are the analytical tools that we use to evaluate vertical mergers, like VGUPPIs? And finally, in particular with respect to the question of guidelines, what would new guidelines include? So there's a lot to talk about, and I look forward, we have some of the real great minds on this issue here today, and I look forward, either today or later, hearing from them. Our second topic today is the Consumer Welfare Standard. And as I think most folks, even out in the public, know, this is the standard that we use across the board, mergers and conduct in courts and at agencies to judge anti-competitive conduct. It is not only a standard that we in the US apply, it is a standard that is used by competition agencies around the world. It is an economically grounded standard, and it requires that there be harm to consumers for conduct to be condemned. Mere harm to competitors is considered insufficient. So let me repeat that again. There has to be harm to consumers, not just competitors. The reason that is so, the reason harm to competitors is considered insufficient is because sometimes a less efficient firm losing sales or market share to a cheaper, more innovative, or efficient rival can be, and often is, consistent with vibrant competition and with outcomes that benefit consumers. Courts and agencies have embraced this standard for decades. Today, there are two very important discussions going on about the consumer welfare standard. And they're happening simultaneously, and I think it is important that we understand that there are two conversations going on. One is a continuing discussion about how we apply the standard, regarding whether enforcement is at the appropriate level, whether it's properly targeted. This is an introspective question on some level, in which scholars, economists, practitioners, and enforcers all ask ourselves, are we bringing the right kinds of cases? Are we using the right kinds of evidence? Should we be doing more or less in certain places? The antitrust bar, the business community, and others benefit from this ongoing and active analysis. The second discussion happening now, and the one on which today's consumer welfare standard panels will focus, is whether the standard is itself the right metric we ought to use, thank you, in antitrust enforcement and in antitrust law. Some argue that enforcement under the consumer welfare standard has failed because of the law, and accordingly that we should reform the law. The FTC's hearings have addressed, as I said earlier, and they'll continue to address certain assumptions that underlie these claims. For instance, last month, we heard about concentration and competition. Today, our panelists will explore how the consumer welfare standard, as we know it, came to be, and propose and consider alternatives. I'm interested to hear how the proper goals of antitrust are articulated and on what basis they are justified. Does the consumer welfare standard fail to achieve these goals, and how? I want to understand the proposed alternatives and how they would apply in practice, day in and day out, in antitrust enforcement from the government's perspective and also in antitrust litigation in the courts. I'm particularly curious about whether there is conduct that is illegal today that might be legal under a particular standard. I'll cite as an example the concept of small labor sellers, workers, colluding against a monopsonist. So that's just one example. We talk a lot about things that are legal today that might be illegal, but it is also interesting to consider things that are illegal today that might be illegal. And among the many considerations, I alluded earlier to the fact that globally, we've seen adoption of the consumer welfare standard. I'm interested to hear today how we think that globally a different standard would be applied, and what would that mean really for the national interest generally. As I mentioned at the beginning, today is a heck of a day. We are discussing two fascinating and very important topics, and I'm really interested to hear what everyone has to say about them. So thank you very much.
All right, thank you, Commissioner Phillips. I am here to introduce our opening speaker for our first panel. This is the economics panel. We'll have a second panel on vertical mergers and vertical guidelines that feature lawyers, so this is the important one. We have a great panel, but I'm going to, because of the lights and the unpleasantness of those things, I'm going to have Steve Salop come up here and give his opening remarks. Steve is the professor of economics and law here at the Georgetown University Law Center. As Commissioner Phillips said, his work with Sheffman and others on raising rivals' costs, as well as his work on V. Guppy with Serge Morrissey, are really influential in terms of how people think about vertical mergers, foreclosure, and certainly we use these tools in the Bureau of Economics. And one of the things that I think we want to explore is to what extent, should things like this be put in guidelines. So without further delay, Steve Salop.
Thank you. Thank you very much. Thanks, Bruce. Thank you, Commissioner, for setting the stage. I have a heck of a lot of slides, and this is going to save me several, so I really appreciate it. As I said, I've got a lot of slides, and I'm not going to have time to go over all of them. And so what I'd like you to do is kind of read along, sort of like a class, read along, and then I will highlight the issues that I think are most important on each slide. But to start, by way of introduction, the key points I want to make are listed on this slide. That vertical merger should be focused on oligopoly markets. A lot of the criticisms one hears about vertical merger enforcement, why vertical mergers are competitive, relate to vertical mergers in either perfect monopoly or perfectly competitive markets. Second point, that I don't think that the analysis of vertical and horizontal mergers should be treated as inherently different in oligopoly markets. Vertical mergers, as I'll discuss, can lead to unilateral harms, can lead to coordinated harms, just like horizontal mergers can. In some sense, the vertically merging firms should be thought about as indirect competitors in the pre-merger world, and that indirect competition is eliminated. As I point out on this slide, in vertical mergers, the form is vertical, but the harm is horizontal. We're not talking about something that's fundamentally different. Another key issue is whether, and Commissioner Phillips pointed it out, whether there should be a pro-competitive presumption, in particular a pro-competitive presumption following from elimination of double marginalization. And this is a key issue, and there's a lot of disagreement on the panel about this issue. In my view, that the efficiencies from vertical mergers, including EDM, are neither inevitable nor necessarily merger-specific. As I'll discuss, the Cosian door swings both ways. Very often, efficiencies can be achieved by conduct short of merger. And in my view, and I think certainly in horizontal mergers, and I think it's sort of generally accepted, that in merger analysis, only cognizable efficiencies get to count, and efficiencies are only considered cognizable if there are verifiable merger-specific and pro-competitive. And the burden in merger law and across all of antitrust is that the parties have the burden on efficiencies, not the government. And so my hope is that the vertical merger guidelines finally are revised after all these years, and that when they are, they should reflect this set of points. So the question, should the vertical mergers be revised? Well, Commissioner Phillips laid out why they should be. The 84 guidelines are woefully out of date. I think we saw in AT&T Time Warner that courts are not very good at analyzing vertical mergers. In my view, the staff and the commissioners could get better at analyzing vertical mergers as well. And of course, it would be useful for outside parties, both the merging firms and their counselors. So what are the arguments against revising the merger guidelines? I've set out the standard arguments here. I'm sure we'll discuss them both in the economics panel and in the legal panel as well. One is that you don't need to revise the guidelines because, hey, we already know how to analyze vertical mergers. Then there's another counter argument that we shouldn't revise the guidelines because the issues are so complicated, we couldn't possibly write down guidelines that are sensible. And people argue the benefits are low because there have only been 50 some odd consent decrees. Actually, it's 58 through June of this year in the last 25 years. And the benefits are low because there shouldn't be any vertical merger enforcement. That's what someone like Professor Bork would argue. And that leads to counter-argument number 2, which is the one I really like. And I think it's the one that lies below a lot of the points that people make under counter-arguments number 1. The idea is that if you revise the vertical merger guidelines, that education is going to lead to more enforcement. And it's an ignorance is bliss argument. Better we shouldn't know what the possibilities are because the other way people put the argument is the staff will have a new toy and therefore they'll want to bring cases. And I think that's silly. I think that if we revise the merger guidelines, it will not increase false positives. Instead, it will reduce false negatives. Okay, so vertical mergers, moving on, vertical mergers, they include both purely vertical deals, but also complementary product deals. So a case like Ticketmaster, Live Nation, they were not vertically related, they were both selling complements. Sometimes mergers are both horizontal and vertical. So for example, the St. Luke's case that the FTC brought, the Idaho hospital case, the FTC focused on the horizontal aspects. At the same time, there was a private case that focused on the vertical aspects. The St. Luke's was taking over a large physician practice as well. Sometimes it's automatically vertical plus horizontal because one of the horizontal merging firms is already vertically integrated. So there was a deal 5-6 years ago where in the door skins market, molded door market, where Geldwin bought a small competitor, but Geldwin was both made the door skins and they also made the molded door. And that's a case where a private case in Richmond just recently undid that merger. Professor Shapiro was the expert for the plaintiff. Maybe he'll talk about that. Maybe he'll talk about that later. So wide range of deals that are vertical mergers. The basic economic benefits and harms, Commissioner Phillips laid them out, so I'm just repeating them here. I'd say in the foreclosure area, what I told my students when I hadn't coincidentally taught this on Tuesday, that input foreclosure is the stronger foreclosure story than customer foreclosure. I don't think there's a lot of disagreement about what's in blue and black font on this slide. I think that the economic arguments for both harms and benefits are pretty well known. I think where there may be controversy is what's in the green font, which are my views, that enforcement should be focused on oligopoly markets, that only cognizable efficiency should be credited, and that what you need to do is analyze the overall effect on consumers using a fact-based analysis of both harms and efficiencies. Okay. Oh, that's 22 minutes left. Okay, fine. Key policy issues. I think I have. I've laid them out. The points on this slide are really key, but quite repetitive. The issue is the key policy issue is, are vertical mergers so much less concerning than horizontal mergers that the legal and policy analysis should differ substantially. In particular, should vertical mergers be treated systematically? Should they be systematically more permissive than horizontal mergers, and if so, how? I don't think so. Would be my simple answer. Okay, so why? Commissioner Phillips said hopefully we'll figure out how we should analyze the economics, and I'd say this slide, this summary slide, is really pretty important for my view of everything. So, in my view, the foreclosure harms, if we start with foreclosure, the foreclosure harms from vertical mergers are similar and not less inherent than the harms from horizontal mergers. The vertically merging firms are indirect competitors, can be thought about as indirect competitors in the pre-merger world, and that indirect competition is eliminated. The V-guppy, the vertical guppy, was mentioned earlier. The vertical guppy looks a heck of a lot like a horizontal guppy, and that's because, at least the upstream vertical guppy, that's because the analysis is very similar. Vertical mergers are common. Vertical integration is very common, but so is horizontal integration. Most firms produce multiple products that are substitutes for one another. So that's not an inherent difference. Partnerships among competitors are common. Horizontal mergers are common. The idea that are vertical mergers inherently pro-competitive? Well, so are horizontal mergers. The guidelines say so. We know very few horizontal mergers are disturbed every year. Also, vertical merger efficiencies are not inevitable. I mean, vertical integration is common, but so is vertical non-integration. There's an awful lot of companies that are not vertically integrated. And we have lots of examples in which vertical integration has failed. Pepsi's acquisition of KFC and Pizza Hut. Of course, Coca-Cola has not merged with McDonald's. Sony Betamax, which was vertically integrated, was beat out by JVC. In cable, we've seen integration and disintegration occurring over time. I note that even Alcoa, the fundamentally bad vertically integrated monopolist, has broken itself up into Alcoa and Arconic, upstream and downstream. So I think that's a similarity with horizontal as well. And finally, the key policy issue is the issue is not about whether or not there are efficiencies. The issue is whether the efficiencies are merger specific. And as I pointed out before, Coase stressed that you can get vertical integration by contract. Very often you can achieve the vertical efficiencies if they occur but with contracts rather than having to merge. Okay, so let me talk a little bit about this unilateral. I don't want to talk about the guppy. We'll leave that as a homework assignment for you, but rather this idea that the firms are indirect competitors. So here's our basic story, and I've got an upstream merging firm, downstream merging firm. I've got them in green font. There's a downstream rival. And the way I've set this up, because I like to keep the harms and the benefits separate. You can have harms without benefits, you can have benefits without harms, or they can go together. So here, the upstream merging firm is simply supplying, in the pre-merger world, the downstream rival. And so since it supports the downstream rival, helps the downstream rival keep its costs low, well, and the downstream rival competes with a to-be downstream merging firm, you've got this competition implies that there's indirect competition at that level. Okay? And if there's a merger and the upstream merging firm raises the price to the downstream merging firm or cuts them off, that indirect competition is reduced or eliminated. And that's the sense in which a vertical merger can, purely unilaterally can reduce so-called horizontal competition. John, I sometimes focus on the fact that it would cut the rival off. John Baker focuses on the idea that it would raise the price of the downstream rival, and that would lead the downstream rival to involuntarily collude. In effect, it would be forced to coordinate with the downstream merging firms. Okay, so at the unilateral level, the issues are really not fundamentally different than in horizontal mergers, and that's why the guppies look similar. You can read this. This just says what I said in words rather than with the picture. At the level of coordination, vertical mergers can lead to coordination. One way it can lead to coordination is by disrupting or eliminating mavericks or disruptive buyers. So if the upstream merging firm is a maverick, after the merger, it may not want to behave as a maverick because its downstream partner benefited from, it may not want to eliminate coordination at the upstream level because if there gets to be coordination at the upstream level, it'll be the unintegrated rivals that get harmed. Meanwhile, its downstream merger partner will then have a cost advantage. So if the upstream merging firm is a maverick, it may no longer want to act like a maverick after the merger. Similarly, if the downstream merging firm is a disruptive buyer that prevents coordination at the upstream level, it won't want to do that after the merger. It would say, gee, why should I prevent coordination at the upstream level? I will be protected because I'll get my inputs from my partner, and it can raise the price to my downstream rivals. And then third, if there's a downstream maverick, not a merging firm, well, that gives the upstream merging firm an even greater incentive to raise rivals' costs. So in those three ways, within the context of horizontal merger guidelines analysis, a vertical merger can lead to the same type of harms. There can be other coordinated harms as well. There can be the classic information exchange harm. It can encourage, within the context of unilateral, it can encourage reciprocal pricing or reciprocal coordination, which is a point I'll point you to my Yale article rather than talk about here. It's important, this issue of the reciprocal licensing, I think is important as a practical matter because with NBCU merged with Comcast, and if Time Warner AT&T goes through, then you're going to have these two vertically integrated firms that will have an incentive to engage in reciprocal licensing. If there'll be another merger, right, when Charter buys Disney, you'll have three, or Verizon buys Disney, and then you'll have an incentive for them to use cross-licensing of their content in order to raise their own costs and thereby push up subscription prices. So, you know, I think that's a retrospective we might want to do going forward to see what happens to the cable industry. Okay, in terms of efficiencies, you know, this is where the controversy is. Both horizontal and vertical mergers can lead to merger-specific efficiencies. I agree with that. And, you know, as a result, many firms produce substitute products, whether it's from economies of scope, sharing information about customers, reputational goodwill, and the externalities that creates, and so on. But, you know, that's true for vertical mergers as well. Okay. Now, I don't think that the efficiencies are enough to call for a different approach for enforcement for vertical mergers in oligopoly markets. And so I lay out, you know, these 4 bullets here. I don't think Bork carried the day. I don't think the econometrics carries the day. I don't think the fact that competitors complain carries the day. And I certainly don't think that Sylvania and Legion lead to that. And so I think once you accept the fact that these justifications are weak, it can refine the analysis and also avoid confirmation bias, both by merger analysts and by district courts. I'm not going to name names here, but you can name your own names about who suffers from confirmation bias. So let me go through this. First, you know, Bork. Bork said foreclosure is just illusory. He had this great line that the FTC should have held an industry social mixer rather than bringing a vertical merger case. Well, I think we know at this point that foreclosure is real. There can be input foreclosure. There can be customer foreclosure. Markets do not inevitably self-correct, contrary to what Frank Easterbrook would like us to believe, especially if the conduct raises the costs of rivals or erects barriers to entry. We have examples of cartels with large numbers of members going on for a decade, vitamins, for example. So the self-correction idea, limited. And an exclusion, the reason why there's self-correction is argued is because there'll be entry. But if the exclusion leads to barriers to entry, that doesn't work. So that fails. Single monopoly profit theory, no longer valid. It's valid in very, very limited circumstances where you have two monopolists, upstream monopolists, downstream monopolists, protected by durable barriers to entry. They have to be real monopolists, not because each one could be a potential entrant into the other's market. The fact that there's only one, we know, 100% market share does not necessarily imply that you've got monopoly power. As I keep saying, maybe if I say it often enough, you'll all believe it, elimination of double marginalization, EDM, is not inevitable and may not be merger specific. It's hard to integrate. There are principal agent problems within the firm, incompatible technologies. But we'll talk about that a little more. Okay, so EDM. I think, pretty much this, I've already probably laid out all these points. We can often achieve vertical merger efficiencies by contract without the potential anti-competitive harms. And that should be an issue in every vertical merger case. EDM is a wonderful story. It's just not inevitable, and it's not always merger specific. EDM can sometimes be eliminated with nonlinear prices or quantity forcing contracts. There are also EDM and the incentives to eliminate double marginalization is limited by opportunity costs, as we talk about in the Moresi Salad paper. key point in my view, the failure to eliminate double marginalization in the pre-merger world does not prove merger specificity. The failure to achieve it could follow into the post-merger world as well. So what firms should need to justify why they couldn't eliminate elimination of double marginalization in the pre-merger world. Econometric evidence, we'll talk about it. We'll talk about it in more detail later. Some studies are not capable of distinguishing. A lot of studies actually show harm from vertical mergers. Gilbert and Hastings, Luco and Marshall, but we'll talk about them later. Some of the theories test, some of the papers test the wrong theory, and of course they're limited by the data that's available. So we've got a lot of the evidence on vertical mergers is beer and cable because they've got good data, but the world's bigger than beer and cable. Complaints by downstream competitors, common story. If the merger reduces costs, competitors will complain, but the merger's good. If the merger will facilitate coordination, then competitors will not complain because they'll benefit. That means the merger's bad. Well, and sort of my poster child for this is Posner's opinion in the Hospital Corporation of America. Posner said, the most telling argument for the merging firms is that the competitors complained. And we know competitor complaints go in the other direction. But what's interesting about that opinion is 4 pages earlier in the opinion, Posner said, the way anti-competitive harm will occur in this industry is that the leading firms will prevent entry by by new competitors or expansion by fringe by using certificate of need regulations to block their entry. So he laid out the very reason why the complaints by competitors actually were consistent with consumer welfare, yet he never linked it. He's a great man, but this may have been confirmation bias. How do we explain that he missed that point? Lastly, Sylvania and Legion, people argue, well, there are all these efficiencies from vertical restraints, and they should also lead to, what we know from them should lead to more permissive rules on vertical mergers. Well, I just point out that Sylvania was a manufacturer with 3% of the market in a competitive industry. Legion was in a competitive market as well. They were also intra-brand restraints, not inter-brand restraints like vertical mergers, and we know that inter-brand restraints are more problematic from a competitive point of view. And finally, despite the literature, what the Supreme Court said, and that's one of my sacred books as well, by the way, is the law. The Supreme Court did not mandate a permissive presumption for intra-brand vertical restraints. They said rule of reason. Straight old rule of reason, which of course, essentially in decision theoretic terms, reflects a very neutral, competitively neutral presumption, not a pro-defendant presumption. So I think that's the basics on why we should not be more permissive with respect to vertical mergers. The legal context, I don't have a lot of time left. I think that, well, let me just go here. I think we should basically be following the 3-step rule of reason that's established in Baker Hughes and Hines for horizontal mergers. We should port that over to vertical mergers as well. That's the way Judge Leon wrote it in AT&T Time Warner. That's the way DOJ argued it in AT&T Time Warner. And I think that an important point here is that the standard of proof builds in a greater concern with false negatives than with false positives. That's what the Clayton Act is all about, incipiency in the Clayton Act. So that's another reason why I think the vertical merger law should follow horizontal merger law. And I personally hope or expect that the DC Circuit is going to come out that way in AT&T Time Warner. I note here, in sort of the really crucial point in terms of the policy discussion that we've been having, of where do you put the efficiencies in horizontal mergers in the standard rule of reason across all of antitrust. Efficiencies are step 2. They're part of the rebuttal case. The plaintiff needs to show harm. If the plaintiff can show harm, then the burden shifts to the defendant to show some merger-specific, or in the case of restraint-specific efficiencies. If the defendant successfully shows that, then the burden shifts back to the plaintiff to carry the burden of persuasion that there's net anti-competitive effect. So step 1 harm analysis is ignoring efficiencies, is there likely harm? Then step 2 says, well, there are efficiencies. Then step 3 says, okay, how do you balance the effect on consumers from step 1 and step 2? And the people argue that you shouldn't follow this because vertical mergers are inherently highly efficient and pro-competitive. Well, I've answered why I don't think that's right. Another argument is that you can't have a Philadelphia National Bank presumption because the HHI doesn't rise in horizontal mergers. But this 3-step rule of reason you can do without a presumption. It's done in the rule of reason without a presumption. And you can do it here without a presumption, or you can create a presumption using different elements. Presumptions don't have to be increase in the HHI. And I've got a slide that talks about possible presumptions in vertical mergers. I note that the DOJ no longer thinks what they thought in 1984. These are the DOJ's proposed conclusions of law in the AT&T case. And I've underlined the ones that I think are notable. So they buy into the idea of incipiency. They say the relevant standard should be reasonable probability. They say you should use the same Section 7 standard for vertical and horizontal. They say you should not have to quantify up to the 4th decimal point. They say you should follow burden shifting, use the burden shifting rule, and the burden is on the defendant to show efficiencies, and the efficiencies only count if they're merger specific. Okay, so how would we do that? Well, in this limited amount of time, I just want to point you to the bottom set of bullets, which are possible presumptions that you might use in vertical mergers. For example, one merging firm is dominant and the other is a critical entry, supplies a critical entry, or the upstream firm's a maverick, the downstream merging firm is a disruptive buyer. I want to emphasize these presumptions are the way the law works is there are presumptions, and then there's case-specific evidence. So these are presumptions that would affect the step 1 analysis. So they're presumptions about harm, not presumptions about net competitive benefit after you take potential efficiencies into account. Okay, so I think the arguments against these presumptions are all, well, there's efficiencies. Well, there's efficiencies. Well, there's efficiencies. Okay, but step 1 is ignoring efficiencies. What's the likely effect? So I also, I think there can be safe harbors as well. In my paper with Dan Culley, we suggest a safe harbor if the HHIs in both markets fall into the safe harbor, if both markets are unconcentrated, and we have an adjustment there that not just the plain old HHI, but also an HHI adjusted for if you take out the merging firms. Is the HHI also unconcentrated? Since foreclosure sometimes eliminates competition by the merging firms. Okay, there'd be 2 kinds of rebuttals: the usual structural rebuttal, no barriers to entry, etc., or there's the efficiency rebuttals. And I've already talked about the fact that I think merger-specific, verifiable. Okay, two interesting issues. I think maybe I'll take 1 minute over just to introduce them. What if there's only harm to some competitors? I'm sorry, to some consumers, but not others. So, for example, in the FTC did a consent decree on these 2 soft drink bottler mergers. A study by Luco and Marshall said as a result of this, the price of Coke and Pepsi went down, but because their bottlers bottle for Snapple and, or for Dr. Pepper and 7-Up, the prices of Dr. Pepper and 7-Up went up. So in that merger, is that merger okay or not okay if you knew that? Well, some people would say you should, just look at some kind of representative consumer that drinks both, but under merger law, usually you can define a market for a targeted customer market, a price discrimination market. And in that case, the harm to the 7-Up and Dr. Pepper consumers would define a relevant market, and that's cognizable harm. And if there's harm in any relevant market, then the merger violates Section 7. So you'd have to, no cross-market balancing, says Philadelphia National Bank and its progeny. So that raises an issue whether we should follow that. And then lastly, what if there's harm to the downstream competitors? And yes, that's harm to competitors, but they're also customers. So is that enough, or do we need to show harm to the ultimate consumers? And that's a policy question. Interestingly, DOJ said it's enough to show harm to the other cable companies, to the mid-level people, to the competitors, that you didn't need to show harm to consumers. Though, in fact, in their argument, their factual analysis, they claimed there was harm to consumers. So I just sort of leave that out. Maybe we'll talk about it more, just sort of to let you think this is not totally stupid. Suppose the merger facilitates collusion among the upstream firms. Well, then, should you have to prove harm to all the way downstream, or should it be enough to show harm to their customers? Good question. So remedy, no need to talk about remedy. So in my view, new guidelines are needed, and they should follow Baker Hughes, and they should follow the policies that I've suggested. Thank you.
Thanks, Steve. So I guess I'll invite the panel to come up. We have a great panel, and we're going to give each of our panelists 12 minutes. And after that, we'll have a panel discussion and audience Q&A that lasts a little under a half an hour. You will see Derek Moore. He will have note cards, and if you have a question, get his attention, and he will give you a note card, or somebody from the staff will give you a note card and write down your questions. They'll get passed up to me. All right. I was looking forward to doing this panel in September because it was such a great panel, and then the hurricane didn't come, and it was a nice sunny day, but weather forecasting is an inherently difficult and error-prone activity, just like economics. So we're happy that everybody was able to come. We have on the panel, who will be up first, Dan O'Brien. He's the Executive Vice President of Compass Lexicon, and we were talking before, has had more positions at the DOJ and FTC than anybody else I can think of. We also have next Margaret Slade from University of British Columbia, Vancouver School of Economics. We have Carl Shapiro, who is the Transamerica Professor of Business Strategy at the Haas School of Business at Cal. That's what we call him, Berkeley at UCLA. He's also emeritus and also has a position at the Department of Economics. Finally, there are some good things that come from weather delays, and that is we were able to have Francine LaFontaine on the panel. She originally had a conflict, but because we moved the date, or the hurricane moved the date, Francine is the Senior Associate Dean for Faculty Research, and she had my job as the Bureau Director just a short time ago. So I'm looking forward to a great discussion with the panel, and I'll just turn it over to Dan.
Thank you, Bruce. Thanks, Bilal. Thanks, Commissioner Phillips. And thanks, Steve, for putting together a great talk on a really interesting topic. It's an honor to be here on such a distinguished panel to talk about this important topic of vertical merger guidelines. I think, let's see, is that working? Yeah. So guidelines have two primary benefits, I think. One is to provide information to companies so they can avoid going down unproductive paths. A second benefit is to help prevent untethered arguments. I think both benefits are quite important, and on that basis, I generally support guidelines whenever useful guidelines are feasible. An issue to keep in mind with any set of guidelines is that anything that guidelines say is likely to become an important focus of the analysis. For this reason, it's important to state only robust principles when constructing guidelines. So guidelines should lay down general principles that the agencies will use to evaluate conduct. What principles might vertical merger guidelines articulate? Let's consider some candidate principles for vertical merger guidelines. Consider candidate principle 1. Harm from input foreclosure is more likely the more market power a supplier has. By input foreclosure, I mean actions by the merged firm's upstream division to raise costs of unintegrated downstream competitors. For example, input foreclosure would occur if Time Warner raised the price of content to Comcast, say, after merging with AT&T. So it might seem uncontroversial that the risk of input foreclosure would increase with upstream market power, but there's a problem. Vertical and complementary product mergers between firms with market power create downward pressure on price that grows with the extent of market power. In fact, in textbook models, the downward pressure often dominates the foreclosure effects and often rises faster with market power than the foreclosure effect. So this does not mean that the foreclosure effect never dominates, but there's a very important point here that no one should miss, and that is that just as a merger between two substitutes in a concentrated market puts upward pressure on price, a merger between two complements in concentrated markets puts downward pressure on certain prices. The math is actually identical, except for the sign of the diversion ratio, which is positive in the case of substitutes and negative in the case of complements. So the logic that leads to, for example, a rebuttable presumption of harm for horizontal mergers in concentrated markets seems to suggest a rebuttable presumption of benefit for complements mergers in concentrated markets. I would add that the benefit is not limited to the elimination of double marginalization. Combining complements promotes complementary investment incentives too. I've always thought of the elimination of double marginalization as kind of a metaphor of internalizing the externalities from combining complements in ways that cause the firms to jointly do more of good things than they would have done if they were independent. Of course, complements mergers can have other elements that are important. They can create foreclosure incentives, which need to be balanced against the joint pricing and investment benefits. And complements producers can try to contract around pricing and investment externalities without merging, in which case the merger might not create these benefits. Empirical evidence, I think, indicates that firms don't contract around the benefit externalities completely, and we'll hear a little bit more about that later. Next, consider candidate principle 2. Harm from customer foreclosure is more likely the greater the market power of the downstream firm. By customer foreclosure here, I mean actions by the merged firm to exclude unintegrated upstream suppliers from the market. For example, AT&T might stop carrying Fox programming after merging with Time Warner. So this principle sounds reasonable too, right? But once again, there's a problem. Suppose the downstream market is monopolized, which is the most market power you could have in the downstream market. Downstream monopoly makes it quite likely that firms will write efficient input contracts. In this case, the merged firm's static incentive to foreclose rivals selling into the monopolized market is no different than the incentive of the downstream firm prior to the merger. The merger might still raise dynamic foreclosure issues, and the old guidelines allude to this possibility, but it does not enhance incentives to foreclose merely to shift business. So far, our search for robust principles shows that market power has quite different effects, different implications for vertical and complementary product mergers than for horizontal mergers. While market power is surely necessary for harm, it does not appear to distinguish net harm from net benefit for vertical and complementary effect mergers. So let's drill down a little bit. Candidate principle 3 digs a little deeper. That principle is harm from input foreclosure is more likely the greater the downstream value of diverted sales and the smaller the upstream margin. So small upstream margins mean a small EDM effect, and large downstream margins mean a large foreclosure effect. So this principle is in the spirit of price pressure analysis, which looks at how a merger changes the markup equations that come from firms optimizing conditions. Of course, price pressure analysis is a shortcut because changes in markup conditions do not capture full-blown equilibrium effects. But the hope is that this can provide some guidance similar to the guidance provided by price pressure analysis that's now widely used in horizontal mergers. Unfortunately, the interaction between complementary benefits and foreclosure incentives is more complex, far more complex than can be represented by simple arithmetic. For example, the effects can interact in ways that make the equilibrium foreclosure effect actually negative, the opposite of foreclosure. This is one problem, and it's a significant problem. A second problem is what I'll call the internal consistency problem. And the problem here is that the inputs into a simple arithmetic analysis of effects that are as complex as this might not be consistent with the modeling approach that's been adopted, that generated the framework. So this has been a problem in other areas of antitrust. For example, the misuse of critical loss analysis, where we've frequently seen analysis presented where the margins and the actual losses that are assumed are inconsistent with any kind of rational behavior. We don't want to replicate those kinds of problems in the analysis of vertical mergers, and the codification of simple arithmetic factors could lead us down this path if we're not careful. So, oops, still back here. So when upstream and downstream products vary in fixed proportions, as they often do and as we often think about in significant vertical mergers, small relative margins are likely to make sense, small upstream relative to downstream margins, only when one of three conditions holds. Upstream competition might be substantially constraining, prices might be determined through nonlinear contracting, or prices might be determined through bargaining. The first of these factors makes foreclosure unlikely, so let's consider the second two factors. So principle 4, candidate principle 4, harm from input foreclosure is more likely when input contracts are nonlinear. The simplest version of this idea is that bilaterally efficient contracts would transfer the input at marginal cost. So if firms sign such contracts, a vertical merger would not eliminate double marginalization, but it may still foreclose rivals. If that's the case, net harm would be more likely because the input foreclosure effect would be more likely to dominate. But this logic also has some problems. In a multilateral setting, that is in any setting where foreclosure is a possibility, an upstream firm with market power prefers to use input contracts to soften downstream competition. This is better for the firm than engaging in bilateral contracting that inflicts externalities that prevent the firm from capturing the value of its product. The question is whether it's possible for the firm to make commitments that allow it to avoid competing against itself. If so, nonlinear contracting does not increase the likelihood of harm from foreclosure. And having contributed to this, the theoretical literature on this, I am sorry to report that economic theory has yet to answer this question. Whether nonlinear contracting makes foreclosure more likely is an empirical question. Finally, let's talk about bargaining, which has recently become a central focus in important vertical merger cases. The first rigorous analysis that I'm aware of showing that vertical mergers can harm competition under bargaining appeared in an unpublished doctoral dissertation in 1989. In a model with an upstream monopolist and downstream Cornell competitors, I found that under simultaneous Nash bargaining over input prices, what researchers now refer to as Nash and Nash bargaining, leads to a downstream price that is below the fully integrated monopoly level, as long as there's enough competition in the downstream market. So what does that gibberish mean? It means that bargaining gets rid of effectively double marginalization, okay, in which case a vertical merger raises price. Okay, so this shows that it's possible for foreclosure effects to dominate double marginalization benefits under bargaining, but the result's not automatic. It requires enough downstream competition, but more importantly, it assumes that the seller has no way out of this bilateral bargaining trap that effectively causes the seller to compete against itself. The seller has incentives to find ways out of that trap, and I think that should be a focus of some research, and empirical results that suggest that margins are positive at the upstream level suggest that sellers don't find their way completely out of that trap, in which case vertical mergers do eliminate some double marginalization and have benefits, and there are trade-offs to evaluate. So let me wrap up with just a few observations on what new guidelines might say were we to write them. The theoretical literature in the area shows that the effects of vertical mergers and other combinations of complements depend on many, many details. And that makes it hard to identify robust principles, as we've kind of seen. The most well-established principle is that combining complementary externalities, combining complements internalizes externalities in ways that go in the opposite direction of combining substitutes. So if I were to write guidelines, time's up, I would rely on foundational principles. Right, okay. And the most important point to emphasize is that our usual notion that market power makes things worse doesn't apply in the case of vertical analysis. It's really a case-by-case analysis, and I think we do know some things that would allow articulating at a very high level possibilities from vertical restraints or vertical mergers, and the agencies could write such guidelines and use them to try to construct models to bring cases. And of course, consistency of the models internally and logically and consistent with the empirics would be critical to going forward. Thanks.
All right, thank you, Dan. Mark?
So I'm going to change gears a bit and talk about some of the measurement problems. Whereas Dan went through some of the pitfalls of the theories, I want to talk about some of the pitfalls in the empirics and how I don't really think we can fine-tune. So first I'll start with what do we know about integration versus separation empirically, and then I want to talk about quantifying techniques for quantitative techniques for vertical merger assessment. Vertical mergers are not a random sample. They turn to be highly concentrated industries, economies of scope, networks, and so forth. And the challenges tend to be based on a few factors: foreclosure, facilitating coordination and exchange of sensitive information, and elimination of potential entrants. But let's step back and say, well, what do vertically integrated firms do? And there's an interesting paper by Adelaide Hartescu and Syverson. They study vertical integration in manufacturing. Now, of course, not all vertical mergers occur in manufacturing, but it still tells us something. And they don't look at integration per se, but again, just what happens. What they find is that 1/2 of upstream establishments do not ship to their integrated downstream firms. And in particular, the median internal shipment share is 0.4% if you equally weight or 0.1 if it's valuated. So when you don't have shipments, it lessens a lot of the strengths of some of the motives, like foreclosure or elimination of double marginalization. So then why do firms integrate? Well, we have 4 Nobel Prize winners that have studied this question. On the other hand, they haven't looked at oligopolies, which is the interest here. Mostly it's either been perfect competition or monopoly. Nevertheless, they focus on efficiencies like mitigating contract costs, facilitating specific investments, providing efficient incentives for effort or investment, and risk sharing. Now, these, of course, are not related to product flows and pricing, but they're related to the transfer of intangibles, which unfortunately are very hard to estimate. So I think it's very important that we have safety zones, and they could be based on concentration indices. Concentration industries have many known problems, but I don't see a lot of alternatives. They require market definition, but once you have a market, they're fairly easy to calculate. An alternative might be vertical guppies, but I don't know that anybody thinks that this really should be used in screening. There are so many ways to calculate them. The information, I mean, it's simple to calculate once you have the information, but the information that you need is not the sort of thing that you ordinarily have. Cross-price elasticities, marginal costs, and so forth. So usually we have approximation based on prices, shipment, observables, average variable costs, and they can be poor. So for example, often elasticities are based on market share. That brings us back to defining a market. We can't say what the market share is without. Both firms can produce many, many products, in which case you have many, many guppies. Some of them may go up and some of them may go down. And they can have many rivals. So now I'll turn to what the effects of vertical integration are. And again, most studies study vertical integration versus vertical separation, not vertical mergers. And many of them look only at one side, either the costs or the benefits. So foreclosure is perhaps the most studied of the costs. And many of these people define foreclosure as favoring integrated products, which seems like a very bad definition, because if you're going to eliminate double marginalization, for example, you have to favor integrated products. On the other hand, the industries are things like cable TV, cement, iron ore, energy, transportation, which are the types of energies where concerns have arisen. Even within that set of industries, the results are mixed. We have about half conclude that foreclosure occurred. Efficiencies, on the other hand, there's a huge literature, but most of the markets that are considered are not oligopolies. They might be fast food, hotels, retail sales, trucking. The results are overwhelming support for the theories of organizational economics, except for risk sharing. Now, for predicting what techniques, we need some techniques that are going to be, that use only pre-merger data. And I want to talk a little bit about horizontal mergers, because a vertical merger simulation is just 2 horizontal merger models pasted together with a bargaining model. So there are 3 building blocks that you have to construct. The first is demand. We have to estimate demand for brands. Then we have to specify an equilibrium, which is usually Bertrand. And then we have to get marginal costs. And it's quite difficult to estimate marginal costs. So what people often do is they say, okay, they retrieve the cost from a first order condition. So what does that mean? It says, you ask yourself, what would costs have to have been to rationalize the estimated demand and the presumed equilibrium? Well, that means if you get one of those wrong, your costs are wrong. The other thing is that the costs are usually constant, that is, constant marginal costs. So the conclusions, unfortunately, are quite sensitive to these choices. And I've looked at this in a paper, and it isn't just that you get, if you change, say, from one demand specification to another, it isn't just that you get different point estimates, which you would always get. It's the fact that one point estimate may be outside the confidence regions of the other, and vice versa. So they're very, it's one of the things it's hard to justify if somebody else can come back and overturn your conclusions. Okay, predictive efficiencies. Let me go on to, I'll go on to vertical merger simulations. One of them is downstream demand to obtain you need to do the same sort of thing. Only one demand, downstream demand to obtain a matrix of own cross-price elasticities. Then you have to specify up and downstream gains and the bargaining process. So we have a lot more assumptions and modeling choices, which means that vertical merger simulations are going to be even more sensitive to assumptions. To predict efficiencies, you also have to have another assumption, that is, how are products transferred within the vertically integrated firm? And usually it's assumed that at marginal cost, but this may not necessarily be true. Even with horizontal mergers, full efficiency is not necessarily achieved. So there's a paper by Crawford, Lee, Winston, and Koglu, I guess. And it's a very nice paper. They look at both harms and efficiencies. It's very specific to a market, cable TV and satellites, which I think is good. If you're going to learn something, you have to look at the specific market. And they assume Nash and Nash, which is what Dan was mentioning. They conclude that vertical integration can either be beneficial or harmful, depending on your set of circumstances. So the results are quite mixed. What I'd like to do is, is talk about what are sort of my final conclusions. And I think that it's very important to have rules that will tell you which mergers are not going to be challenged. There are about 10,000 mergers a year in the US. Most of those, almost all, do not raise competitive concerns. So you need to have some rules that say which ones are not going to be challenged. I also think that quantitative techniques in vertical situations, they're not that reliable in horizontal situations. They're much more difficult to perform and to get it right in vertical situations, and that efficiencies are much harder to estimate because, unlike the things that we know and are used to estimating, like economies of scope and scale, transfer of intangible assets is not something that and in fact, one of the papers that I have looked at, my own work with co-authors, one of the disappointing conclusions in the horizontal case is that, from a competition point of view, one of the big factors that we find is whether the merger is beneficial or not depends a lot on technology transfer. Whether productivity from the highly productive firm can be transferred to the other firm, or whether they're going to have a merged firm as just the average of the two. Again, this is something that's very hard to predict. We can predict economies of scale, but we can't predict technology transfer. So we need some easily calculated rules of thumb. We shouldn't rely on them too heavily, but we'd like to have them. And I'm skeptical about trying to fine-tune. So to summarize, I think that there should be merger guidelines. They should be short and simple. They should do three things. They should provide, first of all, clear guidance about the sort of mergers that are unlikely to be challenged, and that may be based on concentration ratios. when the mergers are singled out for evaluation, there should be a discussion of the factors that are most likely to lead to competitive harm. And there should also be a discussion in the guidelines of the factors that should lead to efficiencies. And when I say efficiencies, these should be not just pricing externalities like elimination of double marginalization, but production and organizational efficiencies. I don't think the guidelines should contain rigid rules such as price increase thresholds, not one-size-fits-all tests, or boxes to check that straitjacket the guidelines.
Thank you, Margaret.
Good morning. I want to focus on what vertical merger guidelines would say. It seems to me at the end of this process, that's what the Federal Trade Commission, hopefully working with the DOJ, will be, how they'll mostly be using this. So that's what I want to do. So first, and picking up on I think the very helpful framework that Steve Salop has provided us. First, I want to say I think we really very badly need new vertical merger guidelines. I don't know how many of you have actually looked at the lovely 1984 non-horizontal merger guidelines. Let's just say they're badly out of date. As somebody who's worked on the horizontal merger guidelines, one of the things that we paid a lot of attention to when Christine Varney was Assistant Attorney General and I was Economics Deputy was that the guidelines reflect how the agency actually operating. Okay, so it's accurate for the business community. I just think they fail kind of miserably on that score, and it sounds like Makam Delharim agrees. So it seems to me, very much needed. One thing, the 84 ones, that's before it was even unilateral effects in the horizontal merger guidelines. Essentially everything that's been talked about here is not even mentioned in these guidelines because it's about coordinated effects and it's about two-level entry, okay, which are perfectly good topics, but there's been a lot of learning and a complete shift in agency enforcement related to unilateral. And as Commissioner Phillips said earlier, the agencies routinely review vertical mergers, so this is not like it's an irrelevancy, okay? So it seems to me that it's gotten to the point where it's really just way overdue and very important. Now, of course, what sort of threshold we have if we want these to be perfect? Now, you could put up, if you want to put as a standard the 2010 horizontal merger guidelines. If you want the guidelines to be that good, of course, you'll never write guidelines again. So I don't think that should be the hurdle that has to be met. Okay. The other thing is, look, I will be happy to say vertical mergers are generally much less of a problem as a category than horizontal mergers, okay? But that doesn't mean we should ignore vertical, much less have inaccurate guidelines about them. Look, if I have a heart problem, that's very serious, and we would pay attention to it. My dental problems are probably not as life-threatening, but we still should pay attention to those too. Okay, so let's that's why we're here. So I think it's very important that I really urge the agencies to pick up on this and revise these guidelines. Update. Okay. So now, why is it harder? Okay, so I also agree with Dan O'Brien, and I think what you're going to hear from the other panelists, that it is harder to articulate in terms of the economics just what would be the analytical framework, what would be the steps that then would be in the guidelines and used for counseling. Okay, so it is harder than horizontal. And look, it's for a couple of reasons. First, horizontal, you have direct loss of competitors, and we understand that inherently leads to less competition. Then there may be some offsetting efficiencies. And you can study specifically the market or the level at which the merging firms operate. Vertical, it's not a loss of direct competition. Steve can talk about indirect, but indirect is more complicated than direct in my experience in most things in life. And you need to deal with two levels at once. Okay, so it's just inherently more complicated. But there still are, and I think this is essential to what Steve Salop said, there still is a fundamental trade-off. In horizontal, what's the fundamental trade-off? The merging firms stop competing, but maybe they get more efficient. Okay, you got some balancing. And we have a way of dealing with that with burden shifting. In vertical, there is also a similar fundamental trade-off, which is, at least in terms of this unilateral analysis, is that I'll talk about input foreclosure, and my example will be I make microprocessors, and Steve makes computers, and I sell them to him. Okay, so if we merge, fundamental trade-off is going to be the merged firm is going to be less interested in selling the microprocessors to Margaret, who makes competing computers. Okay, that's inherent because the merged firm now has the Steve computer operation, and that competes against the Margaret computer operation. Okay, so that's call that raising rivals cost. That's inherent, and then also there's some inherent efficiency, there are at least possible efficiencies, including elimination of double marginalization. So again, we get a fundamental trade-off. Okay, and that's so the horizontal and vertical are similar in that respect. Okay, but what's different is that in horizontal, what we say is, look, these efficiencies, they don't automatically spring from the merger. So you've got there's going to be a burden, and the party's going to have to jump through these hoops to prove them, either to the agencies or in court. Okay, so we've got some pretty strict standards there in terms of verifiability and merger specificity. So I think what is fundamentally different is that how do we handle the efficiencies in the vertical deals than horizontal? And we're hearing from panelists about these inherent efficiencies, which economists would agree with, including me. Okay, so I want to distinguish then between elimination of double marginalization, which is hard to say, so I'll say EDM, versus other types of efficiencies. Okay, and there's an important economic sense in which the EDM efficiencies are kind of automatic or inherent in a vertical merger, as opposed to other types of efficiencies which may or may not be achieved. Now, what do I mean by that? Let's go back to horizontal. If two merging firms compete, then we say, all right, when you compete, you're going to act as one, and you're going to stop the competition between the two merging brands. Okay, if the merging parties said, oh, no, don't worry, because we're going to operate the two brands separately, and they're going to continue to compete even though they're in the same company, the agencies and the courts would say no. The agents would say that's silly, and the courts would mention Copperweld. What about vertical? Okay, so when Carl's microprocessors merge with Steve's computers, we would say, look, you're going to operate the company as a single entity to maximize overall profits, and that inherently means that we get this elimination of double marginalization. Okay, that is automatic. Okay, so that is an efficiency which is different than other types of efficiencies that might be claimed. Okay, so that is, I think, different in that once we acknowledge that, then we have to ask, well, how do we weigh that against the anti-competitive harms? Let's say the raising rivals cost of charging Margaret more for the microprocessors. And a good way to think about this elimination of double marginalization, there's a number of ways to think about it in terms of the merged firm, but a good way to think about it is that when Steve and I merge, what the Uber boss of the merged company says, Carl, sell your microprocessors to Steve at marginal cost. Transfer them, really, within the company. And then Steve can set the price of the computers to maximize profits for his division, and that'll be great for the overall company. That's one way that could be managed. There are other ways, and that's what the economics tells us. So if originally, I was charging, as the microprocessor was charging Steve, let's say $200 per microprocessor, but the production cost was only $100, there's a margin there. And what the instruction is, reduce the internal transfer price should go down to the true economic cost, which I'll explain in a moment. And so it's the elimination of that one margin that's the elimination of one of the two margins. That's why it's elimination of double marginalization. He's going to earn a nice margin on his computers. That's how we're going to make money here. But we're not going to pick it up at both levels. Okay, so that is going to be achieved. I just think we have to assume that the merged entity operates as a single entity to maximize overall profits, and that means elimination of double marginalization. I don't think we have any alternative as antitrust economists to continue to assume in all merger analysis that the merged entity operates as a unified entity that maximizes overall profits. Okay, so that gives this elimination, and that does create this efficiency. So the key question then is it merger specific? It's not about verifiability, okay, because it's inherent in having a merged entity. Is it merger specific? Okay, so that's where I think guidelines and practice can evolve. Guidelines could, for example, we could say, wait a moment, other people in this industry solve this through contract, two-part tariffs or other type of nonlinear pricing. They find a way to solve this inefficiency through contract. So you don't need a merger, so it's not going to count. Otherwise, you're going to achieve it from the merger, sure, that's a gimme, but you could have achieved it without the merger. Okay, so the fact that EDM will be achieved doesn't mean it's merger specific, and that's something, an enforcement issue is whether the agencies will say, what's needed to prove that it's merger specific, okay? And the approach one approach that I've tended to take in these cases is to say, you ask, have other people in the industry solved the problem through contract? If they have, then why can't you do that too? Okay. Is there indication that you're working on the problem or have a way of solving it so that you're about to solve it? If so, get on with that, and maybe you would do that without the merger. But if nobody in the industry solved the problem and you've tried to do it, and there's no reason why the environment's changed dramatically in recent past to create a solution, then it seems not that likely that you'll solve it through contract, in which case it would become merger specific. So that's just one way to go. I'm not saying that's the only one. That's what I've done in practice. But that's something the guidelines could talk about and certainly has to be handled in practice when the agencies figure out how to treat this efficiency. Okay. One other more technical point on this that is not, I think, widely understood is how large are these efficiencies that we're going to be balancing against raising rivals' costs, for example? So in my example with Steve, where the production cost is $100 for the microprocessor, and pre-merger I'm charging him $200, and everybody else for that matter, I'm charging $200. Okay, and after the merger, it is not true that then the merged entity will transfer the price, will instruct the upstream division to transfer the price at $100, the production cost, because that's not the true economic cost. So if I'm charging Margaret $200 for the microprocessors, if I transfer the microprocessor to Steve, it does cost me $100 production cost. That's a component of the economic cost. But it also means if Steve sells another computer and displaces sales from Margaret, a critical diversion that comes into the raising rival cost, then the upstream division is not going to sell the $200 microprocessor to Margaret. So that margin has been lost. So if, say, 80% of Steve's sales come at the expense of Margaret's computers, then there would be an opportunity cost of transferring the microprocessor to Steve, which would be the $100 margin on Margaret's computer, on the microprocessor sold to Margaret, times 80%, or $80. So the proper instruction for the merged entity would be to transfer the microprocessors from Carl's upstream division to Steve's downstream division at production cost $100 plus opportunity cost $80, $180. So the elimination of double marginalization would reduce the price from $200 to $180, not from $200 to $100. So when you're measuring these things, you need to account for this diversion. Okay, so let me boil this down and address this quickly what Stan O'Brien's principles. I think there is a principle here that can point to both in the direction of safe harbors and presumptions if you wanted to go that way, but it's not based on Herfindahl's and market shares. And that's, I think people get in the horizontal merger mentality, so they want to think about Herfindahl's and market shares, and it's not really the right frame for vertical merger analysis. The key thing is, if you have just input analysis, if you sell the input, take the input, the concern after the merger with Carl and Steve is that Margaret will be denied microprocessors, the price will go up to her for input foreclosure in the normal language. So the key things to look at are not about market shares, but is if Margaret doesn't have the microprocessors from this brand of microprocessors, is she going to be significantly weakened as a competitor to Steve? It's not about not defining markets. That's an economic question related to the business operation. If she can easily replace these microprocessors, no problem. It just, then well, who cares? Okay, then that would be, I guess, just find another supplier, no big deal. If she cannot, and she can't make her products without it, or they're much inferior, or the alternatives are much more costly, then we have something to talk about. Okay, that would be the main screen. Okay, if she really will be significantly weakened without these microprocessors, then we really want to look. So if she doesn't matter very much, then we could be in sort of a safe harbor. If it does matter, then I do think we need to get into this balancing. And this is why I think it's so important to have the guidelines, because if you're going to go to court and do this sort of balancing, I think Margaret just said a few moments ago, gee, of course, all economists know, basically you do a bargaining model and you put it together with a downstream simulation, which makes that seems like a good approach to me, but I'm not highly confident every court will agree with that. So I think the guidelines can play a big role in both explaining to the business community and the courts just how this analysis should go. Thank you very much.
Thank you, Carl. Francine.
Good morning, everyone. Thank you for being here, and also thank you to the FTC and everyone who was involved in organizing this hearing for inviting me to participate in this debate. I want to start by saying that I agree with several of the panel members who have said that there are vertical mergers that present challenges that we should be seriously thinking about. And in particular, as you saw from Carl's discussion, foreclosure is something, or raising rivals' costs is something that we worry about in these particular mergers. What I'm a lot less clear about, even though I also agree, so the horizontal merger guidelines have been a tremendously useful tool for people to understand where we need to go and how we understand the analysis and what kind of mergers are likely to be challenged. They have been, I agree, extremely important, and they should not be the right benchmark. Carl is correct about that, given that they have had such distinguished authors, as well as they have a long history. I also think that the non-horizontal merger guidelines are not useful, really, so I put that aside. But having said all that, I am not convinced that we are in a position to develop sufficient guidance in order to really write this down in a way that's going to help us in going forward on these. So, and the main concern that I have about that is the possibility that we would end up examining a lot of mergers, many more mergers, and there is an agency capability or the capacity of the agencies to handle some of that volume. So let me see it this way. But there's also just simply the possibility that we would hinder a lot of fairly efficient mergers. So it's trading off these things that's making me more nervous about trying to write that down. I also agree that it's very central in terms of the whole discussion that we think about the efficiencies and how to handle them. And the suggestion that Carl made, which is that we would handle double marginalization type of efficiencies in a different way than others, at least gets us a little bit further. I think ignoring them entirely in the first step of the process would be a problem. So let me, with that kind of summary, try to see if I can make these. Okay. So this is just reminding everyone about what vertical mergers are, which is just two different levels of production that decide to get together, or a firm merges with another entity that is in a different stage of production. And most of the time, the way that we think about those is that it is merging the production of complementary products. So each firm is going to be providing an essential part of this, and then we'll be putting them together. So one thing I wanted to highlight is that in the horizontal merger guidelines, there is a statement that says that the interests of firms selling products that are complementary to those offered by the merging firms often are well aligned with those of customers, making their informed views valuable. And the reason I point this out is, again, vertical mergers often involve the combination of complementary products. So that is the fundamental reason, the fact that the interests of sellers of complementary products are aligned with those of customers, which are what the antitrust laws are meant to focus on, suggests that we should have a more positive view of vertical mergers as a starting point. So why that more positive view? Well, there's a number of different things. There are these economies due to removing double marginalization. But in a much broader sense, there's also a number of issues of aligning incentives, reducing transaction costs, as well as coordination in design and understanding quality improvements and other sources of benefits to consumers. So information sharing and gathering and all of that about consumers can be enhanced through a vertical merger. So I want to talk a little bit about some of the arguments that Professor Saleh brought up when he talked about efficiencies, and in particular the fact that he argued that the merger's efficiencies are not specific to the merger, and Carl said a few things about that as well. My concern about, I've spent quite a bit of time studying contracts, and my concern about that is the idea that you can fully generate the same kind of efficiencies through contracts is actually a relatively complicated and it's not so clear. So yes, in theory, we can have models that show that, a contract could take care of double margins, it could take care of various incentive things. We do have that in the theory. But when it comes to practice, the world is more complicated than what the models start from. And in these more realistic contexts, very often contracts don't do the full job of what is needed for what mergers can achieve. So for example, in some of my work, which is in what people sometimes describe as competitive industries and then sometimes not, franchisees, there are lots of controls that franchisors apply to their franchisees, and yet there have been many disputes about where the price should be, and in particular, franchisees wanting to have a higher price than what the franchisor would want. So the franchisor had difficulty getting the price to be as low as what they thought was beneficial to them. So Margaret Slade and I have summarized some of the empirical literature related to vertical restraints in particular, and what we find is that a lot of the contexts where these vertical restraints are used, and a lot of the contexts where we see the empirical literature on the make or buy decision, support the idea that there are efficiencies and resolution of incentive problems that come from these. So let me summarize what I'm trying to say about this. So for example, quantity forcing and two-part tariffs don't easily generate the same outcome as what a vertical merger could do because of demand uncertainty, risk aversion, information asymmetries, all sorts of incentive problems. So continuing on this notion that efficiencies are not merger specific, I want to reemphasize that there are also rules against vertical restraints in antitrust laws. And so to say that the firms could achieve the merger's outcome by using vertical restraints is kind of putting them in a circular motion where we're telling them you can't merge because you could do it by contract, and then we say, but these contract terms are not acceptable. So I think that we need to think a little bit more about the mechanisms by which they can be achieved with contracts. All right. So that's the contract is an alternative to vertical merger argument that I wanted to spend a bit of time on. I also want to briefly mention that, I think that Carl is completely right. We need to get away from thinking about HHI and horizontal merger kind of qualifiers. We need to think in terms of something different, if we're going to think about vertical mergers. And so the V-guppies are, as a screen, I think would be not the right way to go at this point, given what we know and what we don't know about how they behave in different contexts. And then Professor Salop talked about how vertical and horizontal mergers are not inherently different, and I would beg to differ exactly for the reasons that Professor Shapiro pointed out, which is that we need to think differently about those kinds of markets. So I'll say just a few more words about organizing kind of the empirical evidence. Margaret Slade is quite right that much of the empirical evidence on vertical things does not involve vertical merger analysis. It's really about firms that are vertically integrated, do we see them being more efficient or not? So there's a problem with matching the information that we get from this empirical literature with some of the analysis that we would need to do when it comes to a vertical merger. So I'm going to just leave it at that in terms of that literature and say that back to horizontal merger guidelines, what we want in the guideline is something that helps us describe how and why we challenge various types of mergers. And per the horizontal merger guidelines, again, this should be done while avoiding unnecessary interference with mergers that are either competitively beneficial or neutral. So again, we can give some guidance potentially, but in a vertical context, we have a lot more difficulty defining exactly how and what kind of guidance would be useful. And so the concern is that we would end up blocking a number of potentially beneficial mergers. I want to add a few more things to that. Professor Salop talked about presumption. I'm actually going to just skip that. I think I've already said that we need to think, at least in terms of the double margin type of efficiencies, differently from the way that he's approaching this. But what I'm going to do now is to just say that in terms of thinking about vertical mergers, because I have just a few more seconds left, I want to make this one last point, which is that in a theoretical model, it's very straightforward to say what's upstream, what's downstream, what's a vertical merger, everything is clean cut. But empirically, we have firms that are involved in lots of different markets at a time. And so with these very diversified types of firms, the mergers are not purely vertical. They can be also horizontal partially. And so are these guidelines going to be useful only when we don't have horizontal concerns? And are we going to be asking the agencies to spend a lot more time on the kinds of mergers that we're not sure are raising as much of a set of issues as others? So my last slide here says that vertical mergers and vertical restraints can be problematic. We should be reviewing those. But given the current state of theory and empirical evidence, I think that the guidelines are not quite what I would propose at this point. I think that what we need is much more academic work that helps us understand specific industries and specific contexts, and the kind of cases that Professor Shapiro was involved with, the AT&T Time Warner case, to help us develop a better understanding of what is important in these and the kinds of tests and analysis that we could propose. And we just need to make more progress on that. We're not there yet. And I think it's dangerous a little bit to try and go ahead of further analysis in developing guidelines. Thank you.
Thanks, Francine. Okay, we have 17 minutes, and if I let Steve respond, he'll take all 17 minutes. So,
Just the sort of response one would expect
Yeah.
from the Federal Trade Commission.
so we'll contract. I'll give you a couple minutes, and then
How about 2 minutes per person?
2 minutes per person would be great.
How about 3?
No.
Steve, you got 30.
Let me try to be fast then.
So you'll have to figure out which is the most pressing.
Okay, well, on Dan, I agree that, maybe he agrees at the end that nothing is automatic, but it certainly didn't sound that way. I did not say that EDM is never merger specific. I said it may not be merger specific. You know, it may be that there's no double marginalization to eliminate. In all of Dan's canonical models, of which it turned out there were many canonical models, it was all merger specific, but there are other models that I would think were canonical that doesn't happen. For example, Hart and Tirole, 2 Nobel Prize winners. OSS, no Nobel Prize winners, but still a model in which there was no double marginalization to eliminate. Those were the first 2 modern approaches to vertical mergers. Both found vertical mergers to be anti-competitive and no efficiencies. I agree there's multiple guppies, and when you know, what's going on in this Sibley paper, Dasgupta paper, Dasvarma paper that Professor LaFontaine talked about, it's an old model. It's Joseph Spengler's old model. The V guppy U is positive, but the V guppy D is negative. So of course, there's a tension between the two that has to be resolved by an equilibrium or simulation model. And in that model, both prices go down. But you know, that's certainly not inevitable. On Professor Shapiro, his approach, you know, I think that all I'm asking is that you require the merging firms to explain why they did not eliminate double marginalization. And it's not sufficient for them to say, because we didn't, and nobody else did either. Oh, there were bargaining frictions. And you ask AT&T said, oh, there were bargaining frictions. Well, that's like not, that's a conclusion. It's not evidence. I think even Dan O'Brien would say that's not evidence. So I would like to ask them, why didn't you do it? Now, in AT&T Time Warner, for example, I thought about why they may not have been able to do it. It did not come up in the case except with this term bargaining frictions. And I think the answer there, I think if they were really put to the test, they would say it was because of most favored nation provisions. We couldn't do ED, we couldn't eliminate double marginalization because these MFNs are rampant all over the cable TV industry. But there's 2 problems with that theory. One is, had they said that, well, usually MFNs don't affect the largest firm. And both Comcast, when it merged, and then AT&T, when it merged, they were the largest MVPD. So therefore, the MFN probably did not constrain their ability to engage in EDM. And you can see this as a paper by Eric Hovenkamp and my colleague Neil Sakame that goes into this. Secondly, had it been an MFN that bit on the largest firm as well, what you're saying is these MFNs prevent upstream firms from giving lower prices to downstream firms, i.e. they prevent competition among the content providers. Well, if that's the case, they were saying, well, we couldn't do EDM because there was an anti-competitive MFN. Well, that's not a very good answer. In fact, the DOJ, you know, one of the failures of the Obama administration is they started an investigation of MFNs in cable, and it died. I mean, there you have a restraint that appears anti-competitive, but yet it's been allowed. So, and that's another point about, Professor LaFontaine said, well, you're going to say they should vertically integrate by contract, but that could be illegal as well. Well, the answer is if they're both, the fact that the contract would be illegal doesn't make the vertical merger legal. It makes it illegal too. If you say, well, we could do exclusive dealing, but if that would be anti-competitive, well, then the merger is anti-competitive as well. Lastly, okay, one more. I'm not at my 6 minutes yet.
No.
The studies, the empirical studies of foreclosure, they're really, I mean, you need to look at my Yale Law Journal article, look at the articles written by my fellow panel members, the articles on foreclosure are really pretty bad. I mean, event studies, descriptions, the cable TV studies in your JEL article all test customer foreclosure, not input foreclosure. They don't do a very good job on customer foreclosure because they can't distinguish efficiency from foreclosure. But the issue in cable is not customer foreclosure, it's input foreclosure. And none of them try to do that. So, you know, the fact that Adelaide found no shipments, that doesn't prove no foreclosure. It proves no EDM, but it doesn't prove no foreclosure. Because the best example of foreclosure is when you, in the simplest model, say AT&T McCall did a vertical merger years ago. They claimed efficiencies. But it turned out that AT&T's network equipment was incompatible with McCaw's network. So there was no elimination of double marginalization or efficiency in terms of network formation. The only effect of the equipment part, in principle, would have been foreclosure in terms of the immediate effects.
All right,
And
so Steve.
thank you.
gotta sit down. All right, Dan, you wanted to say something about the merger specificity of EDM?
Yeah, merger specificity of the EDM effect. I think this is important. This is obviously a focus that people are thinking is important for thinking about vertical mergers and what we can say about them. One point that's being missed is that absent a merger, an upstream firm with market power that's selling through multiple downstream firms, a multilateral setting, does not want to write a contract with any one of those downstream firms to transfer the product at marginal cost, okay? Because that dissipates rents in the entire vertical structure, and there's an incentive to try to construct contracts that don't do that. So now I'm not saying, now it could be that in sort of secret bilateral contracting, firms are going to sign contracts that eliminate this EDM effect, but it's also true that a firm that has market power wants to try to soften that. And so, you know, I mean, and that's where all of the literature on vertical restraints was prior to 1990. Okay, and so are we just going to ignore that?
Did anybody else want to take a minute? Carl? Go ahead.
Yeah, I think on the efficiencies that aren't elimination of double marginalization, we really, it seems right to treat them the same as we do in horizontal mergers. So let's take an example. When Carl's microprocessors merged with Steve's computers, we claim, oh, this is going to be great because we're going to have a better way to do the product roadmap and that tells Steve's computers how to design the rest of the machine to use Carl's microprocessors, and we're going to have, you know, a faster product cycle than we could without the merger. Okay, it'll be an efficiency. But I think we really want to say you got to prove that you couldn't do that by having your engineers meet together through a joint venture, through a contract, through sharing confidential information. So I do think the EDM is different because it's inherent than the other types of efficiencies. Two other points quickly. The second one, I think, let me just put out there again, this I think is a good screen, at least for the unilateral raising rivals cost effect here, which is when Carl's microprocessors merges with Steve's computers, and we're worried about Margaret's computers. If she can't get the microprocessors from the now upstream division, is that a problem, significant problem? And if she does lose business, will a significant portion of that go to Steve's computer? So we got two elements there, the importance of the input and the diversion. And if those don't come home, then this theory doesn't get off the ground. So there's a lot of deals that you can say, I'm not worried about at least this theory. Okay, so you can do a lot of screening, call it safe harbor if you want, at least for that theory. Last thing, Francine, you said it's dangerous to move forward. Well, you compare with what? The 849 horizontal guidelines don't look so good, okay? So look, I confess, when I was at DOJ, I was twice there. 95, 96, I'd say, all right, it was only 10 years. We didn't have to do this yet. 2009, 11, we were busy. I did the horizontal merger guidelines. That seemed like a good project. But I just think the time has come. I think it's dangerous not to move forward.
All right, so I'm going to ask one thing, which I am actually really interested in, and it has a lot of it applies to a lot of things that were said today, but one of the things that, and for example, Steve talked about whether or not there should be a presumption. I always think of presumptions as, to the extent they're useful, are empirical based. And so, you know, if we've done, sort of each agency's done an average of one a year for 25 years, there should be, each agency? Two?
Oh, no.
Each agency, so there's two agencies, so, you know, 25 years, 50 challenges, or consents mostly. There should be a lot of stuff we missed, right? And so I'd like to sort of collect on I'd like to collect sort of a list of things that we can go back and look at empirically. I mean, the chairman and myself are both very interested in doing as many retrospectives as we can. I mean, they're hard to do. You need to have data. You need to have a credible control group. But to the extent that there has been sort of almost some, but almost non-enforcement, there should be a lot of, you know, type 2 errors. And so we're really interested in sort of getting a list of things that you think that it would be useful to study. You know, if anybody has ideas, you could say it now or send me an email.
Well, Bruce, you know all the ones you've cleared. Why don't you look at all the ones?
It wasn't me. I haven't cleared any.
Your institution. I mean,
Yeah.
how are we supposed to know which non-visible deals?
Well, I would actually say that's fine. Let's just randomly pick a bunch of them, and then you won't have selection issues. But I tell you, I looked at our resources at BE, and they're not big enough to do that. And so, you know, I think what the other approach is we look at the margin, right? And I know it's hard to figure out what the margin is, so I'd actually like people who've, you know, I mean, a lot of people on this panel to sort of say, you know, this one, and just to give us some guidance of, you know, which ones you think are.
Okay, well, I knew you were going to ask this question, so I made a list.
Well,
Time Warner Live Nation,
Yeah.
you ought to go back and look at. Google DoubleClick, AmazonDiapers.com. Look at, you know, when Joe Simons was bureau director, you cleared Avant Synopsys, you challenged Scitech Digene. Look at those two. Look at NBC Comcast. You know, I didn't see that they lowered price since they merged. So
Okay. No, I mean,
that's my initial list.
We're truly collecting a list, you know, part of the problem is that people ask us to do them, and we'd like to do them, but we don't have the data or a credible control group. But
Yeah, you have CID authority.
yeah, 6B, but yeah. So that'd be great. But and I encourage anybody else who might have candidates to send it to us. Any of the other panels?
So there's not been that many that people have been able to look at.
Yeah.
Again, data is a big issue, and you know, I can think of the soft drink one, that was the Pepsi merging with the bottlers.
Right. Actually, somebody did a study. They actually
Right.
presented.
A couple of them.
Yeah.
And what they found was that the price of Coke and Pepsi and each of these went down, again, as you pointed out, and then the cost to some of the rivals went up, but in total, consumers were better off given who is consuming how much of what.
Which consumers were better off, I'm sorry?
Those of Coke and Pepsi,
Those consumers. And the others were worse off.
as we sometimes have in horizontal mergers
Yeah,
as
but that
well.
makes the merger illegal.
Um,
Not to
Okay,
quibble.
Steve, that's the next. You're on the next panel too. So, how did that happen? We're at Georgetown. You're on this panel. But I mean, so yeah, I mean, from a welfare standard, and then Carl's on that panel. You know, I mean, they're difficult because they're mixed effects, and there's winners and losers. So, all right, I want to get to some of there's actually some good questions on the cards. So. Somebody asked, is there a presumptively illegal vertical merger? My guess is no.
Well, if Steve can't think of one, I guess none of us can.
I presented a list on what you could base presumptions on.
The horizontal merger that Steve had on his slide that wasn't a vertical merger, that he called a vertical merger,
Oh, the
was
one,
presumptively
the
illegal.
Canadian, yeah. Well,
Which one?
But look, I would say, if you have a merger where an input's important, the rivals really need it, all of them, and there's no elimination of double marginalization that's merger-specific, that's going to be looking pretty bad. Okay, now, do I want to say there's a legal presumption? No, I'm just going to tell you the economics. But, those are the sort of fact patterns that you could find pretty quickly, and that would raise a flag.
there's a question for Carl about his recent work, but I'll not do that part. But I mean, the back half is about remedies, right? And if in fact there are useful, I guess, behavioral remedies that would allow us to obtain the benefits of sort of the allocative efficiencies of EDM without sort of worrying about the foreclosure. And any thoughts about that?
Well, the question for vertical merger guidelines is whether the agencies would want to say something about the type of remedies they would or would not accept. Okay, that's not been in the horizontal merger guidelines traditionally, but it could be added conceivably, right? I mean, it's not out of the question. That's been handled separately. Let's just say one advantage of putting that in these guidelines that I'm imagining, that a number of us are imagining, is it would at least indicate where the areas of commonality are between the two agencies. Because if there is a breach there, that seems like it's not good public policy.
So
Right.
I would add, I think, I mean, on horizontal mergers, there's a very, and at the agencies generally, I would say there's a strong preference for structural remedies, right? I mean, in part because they focus on the kinds of things that lend themselves to that. I do think in vertical mergers, we'd have to be a little bit more open to alternatives because it's, again, we want to get some of the benefits that are embedded in these mergers.
Okay.
Well, also, in horizontal mergers, often the remedy is divestiture. And if there are certain products, these are not just single product firms, so if there are certain markets or products that cause harm, that could be a remedy.
All right. We have a minute left. All right. So I want to just go back to the merger-specific efficiencies. And I think maybe it'd be useful just to call EDM an allocational effect, right? It's just DPP. And Francine's slide sort of got at this, but I mean, you could, and Steve said Coase's door swings both ways, right? I mean, I assume you're talking about Coase 37, not Coase 60?
Yes, 37.
Coase 37 really focuses on the cost of using the market as the explanation for why we have firms at all.
That's
right?
1937, by the way, his first article.
37. Well, but you know, it always seemed to me that our efficiency specific, and especially in this discussion, specific to the merger, seems to stand Coase 37 on its head, right? I mean, it really is. He used the cost of using contract and cost of using the market to explain why we have firms at all. And you're asking, well, why don't we just use contracts, you know, instead of actually doing it within a firm? And so it puzzles me, and maybe it's just where I was trained and people who trained me as an economist.
Well, but Bruce, that's not even right in terms of where you were trained. You were trained to learn, there's vertical integration by contract. That's what we learned from Ronald Coase, 1937. Well, if there's vertical integration by contract, and what that meant, especially where you were trained, is it meant you could get all the efficiencies from vertical integration with a contract. You didn't actually need the vertical integration. Well, therefore, that's all I was repeating. I wasn't turning it on his head. I was just stating
that's Williamson
the
and
way
Klein.
we all teach it in antitrust.
Yeah, okay.
Bruce, I just want to know, when you guys at George Mason say you have a football team, is the count for the hike? It's like Coast 37, Stigler 64, Bork 78, hike.
Well, we don't have a football team. In fact, one of the presidents suggested we get a football team, and it almost caused a riot. We have a basketball team, we say Coast 37 and Klein Crawford Elgin. So, all right, I want to thank everybody. I'm sorry I didn't get to all your questions. I will type them up and post them to our panel, and I think there's probably some process through which, if they choose to answer them, or I'll answer them. But I'd like for everybody to thank our great panel. Thank you.
I thought we were going to have 45 minutes for discussion. Did we go too long, or was it shorter than?